Oh. Okay. Is this gonna be good? No, it's a little too, there we go. Oh yeah. Okay. How's this for video, audio quality, framing, and lighting? Viva Frei, Montreal litigator turned YouTuber, and there has been an update in the Candace Owens versus Facebook and Lead Stories lawsuit. For those of you who don't remember, a while back I did a vlog breaking down her lawsuit. She was suing a company called Lead Stories, which is a third-party fact checker that contracts with Facebook to fact check articles published on Facebook. It was sort of a hybrid lawsuit. She was suing Lead Stories for defamation, tortious interference with contractual relations, tortious interference with prospective business relations, and unfair competition. I'll play a clip from my last vlog on the subject just to refresh your memories, then we're going to get into the judgment in this lawsuit, and spoiler alert, the lawsuit was dismissed. Viva Frei, Montreal litigator turned YouTuber, and I finally got around to reading Candace Owens' lawsuit in detail, and it is thoroughly fascinating. It's sort of a mix between a defamation, tortious interference with contractual relations lawsuit. It is mind-blowing, and if you want to know truly how dirty big tech plays, this lawsuit is going to show you. The bottom line of the lawsuit is that Candace Owens and her company, Candace Owens LLC, is suing two companies, third-party fact checkers for Facebook, but she is not suing Facebook itself. She is suing these third-party fact-checking companies for fact-checking that they did on two posts that she made on her Facebook page, which resulted in her Facebook page being demonetized and other damages that she alleges in the lawsuit. All right, so that was the summary of the lawsuit, and like I said at the time, the lawsuit actually raised a concept of law that does not seem to exist in American law, but that exists in Canadian law and French law, known as parasitism. And what Lead Stories is effectively doing in this lawsuit is pure parasitism. They are sucking the blood, sucking the life from the host until it kills the host to the benefit of the parasite, and that parasite will then go on and find another host to suck the life out of. And what do I mean by that concretely? Lead Stories is the third-party fact checker that contracts with Facebook in order to verify and fact-check articles on Facebook, and in so doing, they will go to pages, articles that are generating tons of traffic, qualify them as fake, fact-check, or confirmed false, or needs more context, and then redirect to stories on Lead Stories' website. In other words, they are redirecting traffic from very large pages, articles that are garnering a lot of attention, to their own website, thereby profiting off redirecting traffic from prime locations to their own stuff. But the first issue that came up in this motion to dismiss to change the jurisdiction, because the court did not have jurisdiction to hear the matter, and lo and behold, the court found jurisdiction to adjudicate on the matter, only to dismiss the lawsuit on the substance of the claim. So Lead Stories in particular was arguing that there was no nexus to Delaware, that Lead Stories does not conduct business in Delaware, and Candace Owens ultimately argued that Lead Stories contracts with Facebook to fact-check articles, knowing that Facebook is then going to publish the fact checks in various states, including Delaware. And the judge ultimately said that yes, because this occurred in Delaware, because Facebook contracted with Lead Stories and Facebook does business in Delaware, the court has personal jurisdiction to hear the matter. On the matter of jurisdiction, I thought it was a losing argument from the get-go, because even assuming the defamation side of the claim, jurisdiction occurs typically where the defamation is heard or published. So if Candace Owens is alleging that the fact check, which confirmed that her story was fake, fact, false, whatever, hoax alert, and we're gonna get to that in a second, to the extent that Candace Owens was alleging that the defamation occurred in Delaware, I thought the court was going to find jurisdiction regardless. But nonetheless, the court found that it had jurisdiction only to dismiss the claim on the defamation, on the tortious interference with contractual relations, and tortious interference with prospective business relations, and the unfair competition. How did the court do it? Well, on the substance of the claims that Candace Owens alleges Lead Stories made that were defamatory, Candace Owens and her company was alleging that Lead Stories calling her statements factually incorrect was defamatory. Candace Owens' statements at issue were questioning the way that the authorities in the United States were counting COVID deaths. And she made a statement that the death count is being inflated for the purposes of exaggerating, promoting the pandemic, etc., etc. That is when Lead Stories comes in and says, no, this is false. Fact check false, because Dr. Birx says that the numbers are being counted properly. Other medical authorities are saying the numbers are being counted properly. And ultimately, the court concluded that there was, even within the four corners of the lawsuit and the exhibits filed therein, there was sufficient evidence to justify Lead Stories' claim of false because medical authorities in the United States were saying that Candace Owens' statement as to how they're counting deaths, that they're inflating the death number, was false. And so the court said, no, there are authorities who say this is false, therefore lead story's qualification is sufficiently true or not defamatorily false, which highlights a fundamental problem in my mind of fact-checking in general. Lead Stories comes in and fact-checks and says Candace Owens' statement is false because her authorities say one thing and another authority says another thing, therefore it can be qualified as false. That can qualify it as disputed, but not false. And this just really goes to show the fact that these fact-checkers are not, fact-checking facts. They are qualifying as false issues where there is a legitimate or potentially legitimate dispute. And that is not how fact-checking should work. That is certainly not how you qualify something as false because there is a legitimate or even an arguable dispute over the issue itself. Nonetheless, the judge came to the conclusion that Lead Story's statements were sufficiently true or not defamatory false because there were medical authorities who said that Owens' statement was false. And once Candace Owens loses on the defamation claim, well, then the three other claims fall as well because tortious interference with contractual relations, tortious interference with prospective business relations requires an underlying tort in order to actually qualify as a tort. Legitimate lawful interference with prospective business relations is not a sanctionable tort. Tortious interference with business relations, tortious interference with contractual relations is predicated on an underlying tort. In this case, it was predicated on the underlying tort of defamation. But to the extent the court just came in and said, no, the statements are not defamatory, well, there goes the claims for tortious interference with prospective business relations and tortious interference with contractual relations. What else? And the same thing goes for the unfair competition. The unfair competition, or I think it's unfair business practices, itself is also predicated on an underlying tort, on an underlying unfair practice, which in this case would have been the underlying defamation or defamatory comments, statements, qualifications. But to the extent the court has now said, adjudicated, concluded that the statements were not defamatory, so too falls the fourth claim. But coming back to the hoax alert, because Lead Stories not only fact-checked Candace Owens' statement and said it was false, they qualified it as a hoax alert. And the court, as relates to adjudicating that hoax alert is not defamatory, basically said that it's hyperbolic rhetoric. It's more akin to a statement of opinion, hyperbolic descriptions, and not a factual statement susceptible of being defamatory. And that is how they got around the qualification of hoax alert, which, in my mind, calling something and someone a hoax in some circumstances leads to defamation lawsuits that go all the way to the Supreme Court, and in other cases, they get dismissed on a motion to dismiss, a Rule 12b-6 motion to dismiss. I don't say politics ruins everything for nothing, but it certainly seems that politics ruins everything, or at the very least creates a two-tiered legal system, judicial system, prosecutorial system, everything system. But that is a summary of the lawsuit. Robert Barnes and I will be discussing it during our next live stream, which is going to be tomorrow. If you want to support Robert Barnes and I, you can find us at vivabarneslaw.locals.com, where you can support us, get some great exclusive content, exclusive chats, yada, yada, yada. More important than anything, though, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace. All right, I just have to finish this by reading one section on the hoax alert. Moreover, in Montgomery versus Risen, the United States Court of Appeals for the D.C. Circuit found that the book author defendant's description of the plaintiff's software as an, quote, elaborate and dangerous hoax, end quote, in his book was merely, quote, loose, figurative, or hyperbolic, end quote, and that such language could not serve as the basis for liability in a defamation action. Similarly, the term, quote, hoax alert in the Lead Stories article was used as loose, figurative, or hyperbolic language. It is not reasonably conceivable that readers who read the Lead Stories article would have understood, quote, hoax alert to mean that the plaintiffs were intentionally spreading a lie. Instead, the readers would have understood, quote, hoax alert as a rhetorical hyperbole implying that the Owens post carries inaccurate information and that the readers should proceed cautiously when reading the post.